Hello, everyone, and welcome back to another episode of Letter of Law Interviews. My name is Seth Bharatwaj, and in today's episode, I am absolutely delighted and thrilled to be in conversation with Dr. Amit George. I don't really think Sir requires an introduction, but just in case our viewers don't know him, Sir is a lawyer who graduated from NALSAR, obtained his LL.M degree from University of London, and he also holds a PhD from National Law University, Delhi. He's an arguing counsel, an independent counsel who appears primarily before the Delhi High Court and various other tribunals. He also appears as a guest faculty to deliver lectures and seminars at various universities. In addition to all that, Sir writes a very popular column at Bar and Bench, where he takes us through some of the more important judgments of the Delhi High Court each month. Thank you so much, Sir, for taking the time out and being here with me today. I'm so happy to be speaking with you.
No, thank you so much, Sarthak, for having me over. And I really don't know why I am here, but thank you for the kind words, and thank you for considering me worthy enough to share some thoughts with you. Thank you.
Definitely. So, sir, to start this off, why don't you tell us a little bit about yourself? So you went to NALSAR back in 2004. What was it like studying law back then? Because that was a time when national law universities were just popping up. What were some of the activities you were involved in, and how did you get interested in litigation?
Well, first, congratulations on making me sound really old, which I am. but that's a very valid question, because the law school scene back then was very, very different. I mean, just to give you one illustration, there was no CLAT at that stage. So I remember writing multiple entrances just to see where I could get through. So NALSAR happened, and I would say that NALSAR also, to that extent, yes, in terms of infrastructure, it was reasonably established by then, but it was still, possibly, I think, about 6 or 7 years since it had been conceptualized and set up. So therefore, it was comparatively early days, and I think that is why one of the fond memories which almost all of us have from NALSAR, either it's a fond memory or a horrifying memory, depending on your perception. But because we were pretty much in the middle of nowhere, this village called Shamirpet, which was a good 30-35 kilometers from Hyderabad city. And back then, you did not have the ORR, the outer ring road, which now makes it so easy to commute even to the far-flung areas of Hyderabad. So, it was a very interesting environment, sort of like a large campus in the middle of nowhere, and everybody, sort of spending 5 years stuck together. So obviously, we made some very good friendships then. And even, in terms of the academics, we had some really good professors. So overall, I think from the teaching background and also from what you learn from the peers, NALSAR was a very, very transformative experience. It was definitely a lot of fun. And I think in terms of the difference, well, now when I have law students interning with me, I think generally in terms of the presentation, the networking, LinkedIn, etc., it's far more evolved now. Like back in our time, internships and all were so old tech, low tech in terms of how you would approach them, make a phone call. Even emails were not that, let's say, it was not that ubiquitous in terms of applying to, let's say, individual lawyers. A lot of lawyers, frankly speaking, didn't really look at their emails all that often. So it was very low tech, all of what we used to do, even applying for conferences, etc., going around. So it was a slightly different world, but the fundamentals remains the same. A campus environment, what you do there, it's still the same.
Right. Thanks for sharing that, sir. And after graduation, you took up the position of a judicial clerk at the Delhi High Court.
Yes.
Now, again, so just to conceptualize that question, clerkships these days are more and more popular. We see students actively vying for those positions. Was the situation same back when you took up the position, and what was your entire experience like clerking at the High Court?
Right. So, clerkships were reasonably in demand, definitely in the Supreme Court. But that was primarily from the perspective of, eventually securing a recommendation which would stand you in good stead for an LL.M, particularly an LL.M at an American university. But at the Delhi High Court, to be very frank with you, clerkships were not so popular in the strict sense, but they were more popular, if I may call it that, amongst people who wanted to apply for the subordinate judiciary. So people who wanted to, obviously subordinate judiciary may not be the correct term, but for the district judiciary. So people who wanted to write the examination for the Delhi Judicial Service, they would inevitably take up a clerkship more as, a way to, let's say, learn about the law and then also keep preparing on the side, because there was this conception that it's less strenuous than, let's say, going to a lawyer's office, which of course is a perception I carried, but then there was a very rude awakening once I ultimately got into it. So yeah, so in the Delhi High Court, or I think very few high courts had clerkship programs then. So I don't think, it was popular in the strict sense of being one of the most in-demand things which you would look at once you were graduating. Like amongst the graduating class, everybody had these sort of expectations: a big law firm, a big senior advocate, clerking in the Supreme Court. High Court was a little, let's say, not exactly in the mainstream.
Right. So, sir, these days, what I see, the general responsibilities of a clerk are preparing mostly case briefs, helping the judge with his lectures and other connected areas. Were the responsibilities the same back then? Especially because in Delhi High Court, clerkships, as you say, weren't that popular.
Right. So I think, it varied remarkably depending on the judge concerned. But yes, as you rightly put it, the basic sense of the scope of the work was effectively to proofread the judgments and orders each day, to obviously do a lot of research in terms of assisting the judge with the applicable law. And with certain judges also, you were, encouraged, or you were asked to effectively draft certain portions of a judgment or certain portions of an order, maybe the facts, recapitulating what the counsels argued. In some cases, you were even asked to give draft orders. But as far as the judge who I clerked with, Justice Rajiv Sahai and law, my scope was almost entirely research and proofreading. So that's what I effectively did. And then, of course, as you rightly said, every now and then, if the judge had some sort of a, let's say, academic engagement, say a lecture at a law school or at a judges training academy, then obviously you did the relevant legwork for that as well.
Interesting. So there's a lot to unpack in your answer. So would you recommend that a young law student who wishes to pursue a career in litigation take the opportunity of a clerkship, or do you think better learning happens at a lawyer's chamber?
Right. See, I think in both sets of categories, whether a lawyer's chamber or working with a judge, the learning is obviously, there will be different facets of the law that you are, exposed to. But again, see, this will obviously come from a subjective perspective, because this is how I began my career. But I really cannot recommend a clerkship enough, especially if it is going to be in a court where you ultimately intend to set up your practice. And again, like I said, experiences might vary. There are people who have not had such great experiences in a clerkship for whatsoever reason. I can't comment on that. But I think also it depends on the kind of judge that you get placed with, right? In some cases, you can't really choose. In some, you can. So therefore, for instance, when I worked with Justice Rajiv Sahai and law, I've written about this also. I have always felt that it was a very transformative experience for me, because how I was, in terms of at a character level, at a level of how you understood what the profession required of you, the work ethic, I could sense a significant shift which happened after that 1 year which I spent with him. And aside from that, aside from the personal perspective of, let's say, what you learn, it's also your understanding of how the institution functions, right? Because from a lawyer's chamber, you're always going to be viewing the institution from the outside. But when you work with a judge, for a year, you get an experience, or you get an insight into what really happens behind the scenes. And when I say what happens behind the scenes, most people will say wink, wink, so you got some contacts there. That's not what I mean. I think it also makes you very alive to the kind of challenges that people on the other side face. And so therefore, and I think it gives you some sort of an equilibrium in terms of how you look at the system and how you look at judges. Because the problem is, see, with most perspectives with judges, either you look at them with slavish, obsequiousness, right? Like they're like gods. Mm-hmm. And the other end is, that there is complete criticism. There's nothing right which they can do. So, I think there is, as in most things in life, there is that equilibrium in terms of, obviously, criticism is important for a system to ensure it doesn't decay, it doesn't stagnate. But at the same time, being there makes you alive to a lot of the challenges that they face. And some of which are like superhuman challenges, not easy with the kind of workload that they encounter with. So that, I think, was also very important at a more latent level, that it gives you this sort of, let's say, understanding of what the reality is. So therefore, a lot of things subsequently in the profession when things don't work out, matters don't reach, you're able to take it with a pinch of salt and be magnanimous about it. So that, from that perspective, also extremely important.
Right. Thanks for sharing your insights on that, sir. So moving on,
Yes.
you then pursued an LLM from University of London. Could you tell us a little bit about what prompted this decision and what was your entire experience like?
Right. So I think after a couple of months with Justice Law, considering that I was obviously learning quite a bit, and then at that stage, for some reason, I really didn't think that it was practical for me to take a year off anytime soon and go do an LLM outside. So then obviously I was scouting for an LLM program which would give me that sort of quality, uh, despite doing it, say, from a model where it was not full time. Now, within India, those options were very, very limited. Even today, if you want to do a part-time sort of an LLM degree, the options are not much. Of course, with pandemic, many of them have opened up because it's all become virtual, but not otherwise. So then I decided to undertake an LLM from the University of London, international programs, which gave you the flexibility of writing your exams in the British Council in Delhi. Now, Justice Law was that way very kind that when my first semester exams came around, I asked him if I could take off like a good chunk of time for almost a month to sit and prepare. And he was gracious enough to grant me that. So therefore, I was able to effectively prepare and go ahead with it. So an LM, therefore, as I said, I prepared more in the context of wanting to understand arbitration in greater depth, because my specialization was international dispute resolution with a focus on arbitration. So that is how I went about it. And of course, the University of London program was the arbitration segment was designed by Queen Mary, which is amongst the best colleges worldwide in terms of the arbitration program. So that's effectively how I approached it, because I wanted to do it in India and not take a year off.
Right.
Yeah.
That's interesting, sir. Sir, about LLMs, it is often said that those who wish to pursue a career in litigation, an LLM can be an unnecessary endeavor. What do you think about that? Would you still recommend that students take up an LLM program who wish to pursue litigation?
Right. So I think an LLM is definitely worthwhile in the sense of the larger focus, or the more, let's say, enhanced focus it is able to get you in terms of the specialized areas of law within which you might choose to do your LLM. Because the LLBs in our country, of course, you may have BA LLB, BB LLB, and all of that, but ultimately it's a generalized sort of training program, dehodes those few electives or other seminars which you may take in the LLB program. So therefore, if you want to really specialize or get a more specialized understanding of a particular area of law, LLM is definitely worthwhile. But one issue with an LLM is a lot of people believe that because you have an LLM, you have an extra tag or an extra brand, and therefore it will necessarily, into some way catapult you to great heights in the profession. That is a completely wrong understanding. Because frankly speaking, LLM, PhD, DPhil, none of this matters in court. In court, you are as good as the last order you got. So each day you need to effectively struggle and prove yourself. So therefore, of course, like I said, it's a matter of perception. Somebody may think you are more learned because you have an LLM, or you may have a PhD. So that's a matter of perception. But on the ground level, unless you really perform at the base level of being a good lawyer with an LLB, then an LLM or a PhD to that extent in the profession don't really help. Because a lot of people have that misnomer that I have this extra cloak on top of me because I did an LLM or a PhD. I don't think it works that way in court.
Right. Thanks for sharing that, sir. Moving on, how did you get interested in litigation, sir? Was that always the plan, or did it happen somewhere along the way?
Yeah, so it was a very naive sort of understanding of what litigation required. So see, I always loved debating. So even in law school, that way I never really did any moots. I never mooted. I only did parliamentary debating. So I went across the country, different universities and colleges doing parliamentary debates. So my perspective of being a lawyer was, all about the grandiose argument. Cicero is that way the role model, right? Just stand up and just flummox everyone, just completely obliterate the opposition because of how you speak. And that's what we are fed in popular culture also. Because unless you really experience a trial or argue a matter in court, most of our popular culture depictions of courtrooms are entirely structured around the oral argument. So if you ask me why I don't litigate, it's a very childish and a very naive answer, because I thought, wow, you get to argue in court. It's good fun. So that's precise. That's exactly, if you ask me, why I thought litigation would be a good fit, as opposed to, say, like doing transactional work or working, say, in-house. So, but of course, that I mean, as you would know already after very brief time, that's not exactly what litigation requires. But yes, it's a learning curve. But yeah, that's the honest answer in terms of why I wanted to litigate.
True. So, sir, I was reading an interview that you took online, and I read that you were a junior counsel for about 3 years, and before moving before setting up your independent practice. So, can you tell us a little bit about your initial experiences as a young lawyer, and what was it like litigating?
Yeah, so see, in that sense, I was quite fortunate in the sense that, so my father has used to have a very extensive arbitration centric practice. So at that stage, effectively, immediately after I quit the clerkship, since anyway I had a good interest in arbitration, I thought that at that stage, since he was transitioning almost entirely into a full-fledged arbitration practice, I therefore decided to join him. So for a good 3 years, therefore, it was almost entirely arbitration work. I mean, maybe I would have done 1 or 2 matters which were, let's say, outside of arbitration, but therefore it was a good grounding in terms of what arbitration required. So I spent about 3 years with my father, and then after about 3 years, when I had, like, to a certain extent, done maybe about 2 or 3 arbitrations from start to finish, I decided to try and take a leap outside. So therefore, that obviously was a slightly difficult time. See, as I mentioned, being a second generation lawyer, you have a huge amount of advantages. So I am the last person who you should be asking me about in terms of how it was as a young lawyer, because the first generation lawyers, my peers, the people who've come before me, they are the ones who really struggled. So whatever I say is going to sound like candy floss to them. Whatever so-called challenges I mention is not going to be worth anything. But just in terms of the insecurity, because that, I think, I mean, even if you come from that relative sense of advantage, there is obviously a feeling of insecurity when you first start out in the profession. Because as you see in our litigation system, because of the kind of pendency, etc., which we experience, it is complete chaos. Like when you go to a court, now, obviously, it's less chaotic in the High Court, maybe even more less chaotic in the Supreme Court, but at all levels, there is chaos. Lawyers running around, matters being called, judges being harried with, I don't know how many matters in a day. It's madness, but it's organized chaos, right? It's a well-oiled machine. Every person. So when you enter court, like for the first time, you see lawyers running maddeningly left to right, judges dictating orders, called to passovers, adjournments. So even though it's chaotic, it's like everybody has a space or a place in that machine. And you're the odd one out because you're just standing there watching this universe in motion. And there is some weird force which is keeping it together, stopping it from completely exploding, but you have no idea what that is. So that is something which I felt that all of us experience, because when you first go out there and there's no protective cover of a senior or somebody, suddenly you realize, what am I doing here? Will I ever be able to do anything worthwhile? So that, I think, is there. But ultimately, that's a good part. I think at least that's what I felt in the Delhi High Court. I'm sure that's replicated across the country, is that judges, especially when you're young, when you're a very young lawyer, they do tend to let you get away with a lot of idiotic nonsense. Of course, being rude, being arrogant, that is obviously frowned upon, but a lot of silly mistakes which you might make, like completely fallacious things you may do in terms of the art of advocacy. I have had like some very, very kind judges who in the initial part of the career, even though if I was talking complete bumcum, would basically guide you, or effectively, let's say, come and protect you when there was a very cantankerous senior lawyer on the other side breathing down your neck. So that, I think, was really nice. Plus, ultimately, there is always that sense of affection as that new blood in the profession, etc. So that obviously balances a lot of this out. But again, like I said, there are some days when you don't have a good day. For some reason, the matter doesn't work out, the client is unhappy, etc. So these are, but ultimately, I think the most difficult part is trying to ensure that there is no existential crisis,
right?
And that is that is always lingering, at least in the initial years of the profession. Right. So that, at least, which I thought was one part of the experience which I think most people will to an extent share.
Indeed. So, sir, you went independent after 3 years of being a junior. I understand that everybody's experiences are their own, but what do you think is the right time for a lawyer to go independent after being a junior?
Right. See, I think ultimately the right time is effectively if you are able to ensure that there is at least some work which will come your way to keep yourself occupied. See, money obviously is an important criterion, but see, money is something which, at least in the initial years of the profession, is not something you can take as a given. And when I say money, I mean generating money completely independently from your own, let's say, clientele or whatever is the feeder base that you have in court. So after 3 years in the profession, what ultimately happened is there were a couple of lawyers in the High Court, etc., who used to reach out to me for their arbitration related work. It was not for arguing matters in court, but something fundamental like just looking over an SOC, asking for some recent case law on arbitration, some sort of basic sort of a consultancy. And then, of course, in the few years that I had done work with my father, I had obviously developed some links in the existing clientele, and which I was able to then further generate in terms of other work.
Yeah.
So at that stage, I was in a position where I knew that not only could I continue some of the work which I was doing, at the same time, I could also bring in work from other quarters. So at that stage, I thought that it would not be a situation where I would be sitting, let's say, without any work to do for most of the week, which can be a problem in sometimes. So therefore, I thought, all right, let's try and see. And I also wanted to branch out more into areas outside arbitration. So by then, if you include the clerkship, etc., it almost been about 5 years, at the time when I decided to become independent. So therefore, these are the criteria. It works differently. There are some people who suddenly land a panel. Like I know colleagues of mine who got a panel, let's say with a government entity or with the public sector, and that panel was good enough on its own to be able to sustain a basic level of income or work. So it's a completely differential thing. It's about how you are able to pull that off, whether it's a panel, whether it's networking with other lawyers, generating clientele internally. So that's really the most important. And there is never a right time, because as long as you stay with an institution or with somebody else, there is always that level of security, right? The money which is coming in or the cases which are coming in. So it's always a leap of faith, but it's much harder for a first generation lawyer. So as I said, I'm sure you'll have some very, very good people who've done a lot of good work, but first generation lawyers who I think will answer this much, much better than I can.
Right. Again, thanks a lot for that, sir. Sir, another question about litigation is that which is the right forum to start from? It is often said that, you must get some trial experience before moving to the appeal courts. Delhi High Court has an original side, so that can offer some experience of trial courts within the Delhi High Court. What is your opinion of a young lawyer starting out? Where should he or she start his or her career from?
Yeah, so this is a very, very controversial area. See, I think it entirely, again, depends on who you ask.
Yeah.
See, I know that's the thing. No, there is no real mantra in this profession. I know of lawyers who've started out primarily in the Supreme Court and have now spent 11, 12 years only in the Supreme Court, but are doing exceptionally well. There is a counter also. People who started in the Supreme Court and today, if they decide to go for a trial, they're completely lost. They have no idea what is happening. Then you have people who've started at the trial court level, spent 15, 20 years there. But then ultimately, even then, when they say come to the Supreme Court, they feel a huge handicap in terms of a lot of things. So ultimately, I think it depends on one, what is your real area of what do you want to do? See, if you want to be an appellate lawyer, if you want to be a Supreme Court lawyer, I really don't think it is such a huge loss for you to start in the Supreme Court. Now, I wanted to be, say, a commercial, somebody with more of an outlook on commercial law, because I wanted to specialize in that area. So arbitration, commercial law. So for me, going to the Supreme Court would have been suicidal, because I wouldn't have learned anything which I could have used today, cross-examination, drafting original pleadings, etc. So therefore, that for me was absolutely, like a no-go. But then again, like I said, somebody who wants to do a criminal law practice would never do what I did, because I stuck to the High Court. I did arbitration work. But if I wanted to be a criminal lawyer, that was suicidal. I would have had to go to the lower courts, to the district courts, right, to do, let's say, criminal trial. So I think, of course, the general notion is that, no, you must do everything. But I think as long as you are able to keep a mix and match, for instance, even as a Supreme Court lawyer, you can always associate with a lawyer to do trial work. Say, do a couple of trials with a lawyer in the district court or in the High Court. Similarly, if you're a district court lawyer, do a couple of these SLPs in the Supreme Court from start to finish. So there are ways of supplementing, your knowledge base. But now increasingly, we are living in a world of at least specialization in the initial phases of the career. So therefore, I don't think there is any real, like all-encompassing sort of formula which one might get. The only thing is, yes, it is always good as a lawyer to be as holistic in your understanding of the law as possible. So for that, the wider the range of experiences you get, the better. But as I said, it's not therefore necessary that you must start with the trial court, then go to the High Court, then go to the Supreme Court. That I think is too formulaic in nature, and it ignores, the dynamic nature of the profession today.
Right. That's a very interesting take. Thanks for sharing that, sir. Now, sir, also while being a litigating lawyer, you did a PhD, which is a PhD is generally thought to be the exclusive domain of academics. So what got you interested in a PhD, and what was it like managing such a comprehensive PhD degree with litigation?
Right. So see, ultimately the entire basis of, as I said, I've always had a slight, let's say interest in to a certain extent research and academics. Though of course not at the level of a full-fledged academician. I shouldn't even. I'm sure an academician will be ashamed if I said that what I do is academics. But generally in terms of sustained research work, or especially once you start doing arbitrations, when you grapple with the record, etc. So a PhD was something which I had in mind. And see, my thing was that ultimately in the initial years of the profession, you are not that busy. See, all of us pretend like we are busy all the time. But, the ground reality is we all have stages where we are very jobless. And there are times when you're really busy. So at least in the initial years, the joblessness phase is far longer than the busy phase. So at that stage, NLU Delhi had just come out with I think we were the first batch. And they were one of the few universities that were properly offering a part-time PhD. So otherwise, in a lot of other places, that's not possible technically. So then, since that was an option, I decided to try and see if that could be done. And then, as I said, that time, the work pressure in terms of the profession was not that bad. So therefore, I decided, just to maybe further take forward my interest in research and then explore a different area. So I didn't do my PhD in arbitration or commercial laws. I did it in minority rights, in group rights, in jurisprudence. So I thought, maybe I'll be able to look at something different, read something different, because by then in the profession, it was very, let's say, insular, the kind of work which I was doing. It's all arbitration, commercial. I love doing it, but, it was very straight bracketed. So therefore, that is one of the major motivations, for the PhD at that stage. And then ultimately, when you have the comfort of being able to do it part-time, then I thought, why not?
Indeed. So, sir, looking back, do you think your PhD and your LL.M have had some significant contributions in your practice and your litigation, your chamber practice in that sense? Or do you think, well, it just added to my academic knowledge and not really of practical relevance? What's your take on that?
See, if you ask me personally, definitely, that entire experience of writing that thesis, that it's not easy. So therefore, that sustained, prolonged, detailed exercise definitely prepares you better in terms of collating a lot of information, structuring your thoughts. Because for instance, prior to the PhD, I don't think I used to write a lot. I never wrote much. But after the PhD happened, I think that way also I gained the confidence to write articles, write opinion pieces. So that way, definitely that entire experience really helped in me getting that sort of confidence. But if you ask me from the litigation perspective, see, again, like I said, I don't think it helps so much. See, it's a matter of perception. There'll be some, I know, like when I started counsel practice, there were some lawyers who came to me with briefs saying, sir, aapki PhD hai, isliye client maan gaya. Oh. I don't know what the client thought or what the client's understanding of litigation practices. He probably thought, oh, this lawyer has a PhD, no problem, let me engage him. So, but yeah, so that I am not complaining. I am definitely not complaining, but I am just letting you know that there's really no logic behind it. But as in a lot of things in life, sometimes you have these ancillary benefits of having, say, done a PhD because there's a doctor next to your name. But if you ask me, practically speaking, again, like an LL.M, does it help you in terms of acceptability, larger acceptability in court or not? I don't think so. I really don't think so. But yes, latently, these definitely help. That experience, what you went through, the kind of sources you looked at, definitely it helps, no doubt about it. So it's not something I would say is a waste.
Yeah.
But the only problem is in India, almost everything we do, we have this checklist. Ye kiya to mere ko ye milega. If I do this, this is what I will get. So, so it's not like getting like one of those qualifications where you're qualified as, say, an arbitrator or something. It's not something like that. So if you don't see it from that perspective, you don't have a utilitarian clock next to it saying, okay, now this is what I will get, then yes, definitely. But a lot of people do that and then get disappointed saying, oh, I have an LL.M. Why aren't people taking me seriously? Why did a PhD? Why aren't people taking me seriously in court? It doesn't work that way.
Right.
Doesn't work that way.
Thanks, sir. So moving on, now you also write a very interesting column for Bar and Bench, and you also write other opinion pieces. How did it all start? I mean, you did mention briefly that post the PhD, you started writing more and more, but how did this in review section for Bar and Bench start? And how do you go about identifying the most important judgments of the Delhi High Court?
Right. So see, first I must confess that in the last few months, the in-review piece has been extremely irregular because of a lot of professional commitments, etc. I unfortunately have not been able to do it. So, I shouldn't be taking credit for it. Hopefully I will get back, to form in some time. But yeah, right now is obviously the piece hasn't been as regular as I would have liked it to be. But yeah, in terms of the inspiration for it, see, again, that is one of the takeaways from my clerkship. See, so Justice Endlaw was somebody extremely let's say with a very, very significant emphasis on precedent.
Yeah.
Now, therefore, he was not somebody, who wanted to just write an order or a judgment just like that on first principles. Of course, he decided on first principles, but each and every judgment he gave, he ensured that his conclusions were backed up by the relevant precedent. So therefore, to survive as a law clerk in his chamber, not knowing what the latest case law was, you simply couldn't survive. So therefore, I sort of picked up a habit in the evening of sitting on the computer and, spending about half an hour every day in the evening looking at the High Court website. And at that stage, that was an advantage because our Delhi High Court website, even in 2009 or 10, it was reasonably up to date. Wow. Judgments used to get uploaded pretty frequently. And even today, that is not the case in multiple high courts across the country. But in the Delhi High Court, even way back in 2009-10, that was the case. So therefore, after some time, it becomes a habit. After a year of doing it, even though after I left Justice Endlaw, it continued as a habit. And it stood me in good stead in courts because, when you were able to cite the latest case law, even if you're a very young lawyer, judges took you more seriously. So therefore, that started. So then ultimately, anyway, I used to do this, spend about half an hour, 45 minutes every day reading up the latest judgments on the Delhi High Court website. So at one point, I thought that why don't I start putting it down on paper? And the biggest reason for that was because I used to be very lazy about reading judgments in criminal law and tax because I wouldn't understand them. So I was too lazy to take the effort. So I would only read writ side, original side, all of those civil law elements, dehorse tax and criminal law. So then the column was also a way to force me to read these judgments. Otherwise, I would be too lazy. So it was also an internal exercise of ensuring that I step out of my comfort zone. So that was primarily how it started. And then also the kind of wealth of precedent that the High Court generates, I thought that, very little of it was being captured because of the limitations in terms of course, the size of the journals, etc. Nowadays, the journals, like if you take an AIR, SEC, they are really not able to capture the wide breadth of precedent, especially which comes from the High Courts. Yeah. So that was also one more reason so that, people are, let's say, more up to date with what the High Court is doing, because we have a lot of good judgments every month, which is like really path breaking in all areas of law. And when you say in terms of, how I determine, see the in review piece that way, if you see just from its length, we don't really curate in that sense of what is important or what is not so important. Of course, judgments which don't say anything in the sense that they are settlements, or if they are mere withdrawals, or if the judge has merely noted that in the facts of this case, I'm doing so, then we will obviously not cover that. But almost every judgment which does deal with some area of law, which does debate or deliberate on some principle of law, is included. So therefore, if you ask me in terms of the uploaded judgments, a good 85% of them effectively get covered.
Right. And I do hope you get back to writing the in reviews very soon, sir, because a lot of us, especially the students, benefit from it greatly.
No. Thank you so much for your kind words. Definitely. I will, from next month, I will try and get back to it.
Definitely, sir. So moving on, I'll just quickly come to the final set of questions that I have. Now, sir, you've been an independent counsel for a while now. Do you still get nervous while arguing?
Oh, yes. See, that's, as I said, no, see, I think at every stage in life, when you look at a lawyer, your first impression is, this man is unflappable, this woman is unflappable. How do they do this? Yeah. But, that's what I think a lot of us should be more forthright and frank. And when I speak to some of, these seniors, you'd be surprised at how frank and forthright they are. See, butterflies in the stomach in the morning in court, I think, is something which is natural for a lot of people. There are some people who might be immune to it. There are some, I think, who are immune to it. But I think for the vast majority, including yours truly, definitely there are butterflies in the stomach. And I'll tell you, butterflies in the stomach is not in terms of the fear of the judge. It's not the fear. The fear, in terms of addressing, doesn't, I think, survive after some time. But, sometimes you get some really bad cases. So therefore, in that case, the expectation from the client or the briefing counsel, and you sometimes when you read the brief, obviously you should not identify with the brief beyond a point, but you might think that, oh, this was a good case, or this gentleman or this lady who's come to you, they justice should be done to them. But for some reason, the law is completely against them, or they were not bothered with the record. So the record is now completely one-sided against them. So you have an uphill task. So that, pressure definitely is there, but that's part of the adrenaline. That when, despite all that, when you're able to overcome and the judge agrees, and and then you have like an astounding victory in court, that's part of the the excitement. So if that initial element of that the butterflies in the stomach is not there, then obviously that payout in terms of that that great excitement or joy when you win a matter, that's also not there. So therefore, that is one of the aspects. So therefore, yeah. So anybody who tells you, no, why should you care and anything, I don't think that's the case. For anybody who's, committed and who's, let's say, really concerned about what is going to happen in court, definitely there'll be butterflies. But one thing which happens is that initially what happens in your career is, let's say you have 2 cases in a week. So you will spend 3 to 4 days thinking about that case. What will the judge ask me? Judge may ask me this, he may ask me that. She may, ask me what about this particular admission you've made. But now after the point when you have 2 matters in court, 3 matters in court in a day, then naturally that pressure also subdivides. I don't think it multiplies, it subdivides, because there's only this much pressure which your body can take in a day. So if you have 5 cases, those 5 cases will take it away one by one by one. So that's what people say, like these really the big lawyers who have 10 cases a day, 15 cases a day, people say they don't have time to worry. Because because there's no time. You don't even know what the judge has said. Sometimes you've seen it, like when you're in your internship, some of the big lawyers, the minute they're rushing to the next court, there's no time to even digest what's happened. That's for the briefing lawyer to digest. Did he win? Did he lose?
Yeah.
So that's part of it.
That's true. Wonderful. In fact, I've had the wonderful opportunity, and this is for my viewers, to watch Amit sir argue in Delhi High Court. And if you're ever in court and see sir arguing, do it in the court and listen to him. It's a wonderful, wonderful experience.
But now, so therefore you also know, in each of those moments, there were butterflies in my stomach.
Right. And so, sir, just the final set of questions.
Yeah.
Looking back, sir, at your trajectory, are there some mistakes that you think litigation lawyers could have avoided and should avoid?
Yes, see, definitely. See, now, for instance, when I look back, like at my time in the profession, so for instance, one thing which I somewhat regret is I wish I had done a little bit of criminal trial in my initial years, right? Because even though I ensured that I don't get straight bracketed, let's say, only in arbitration after the first 4-5 years, but the one area where, I always felt a bit of remorse is that I couldn't do criminal trial, because I thoroughly enjoy civil trials. Of course, in the High Court, we don't really get to do them so much anymore, because unfortunately of the kind of pendency that we experience, full-fledged trials now, I mean, unless we have a huge uptick in the number of judges, it's not so easy in the High Court anymore, because largely it's only arguments on interim applications, etc. Even at the original side, cross is now significantly whittled down. Though of course it happens, but it's not center stage as it used to be. Yeah. And but in arbitrations, you still have a lot of cross. So I thoroughly enjoy that. So I wish I could have had that experience or replicated it in a criminal trial also. So that's a very personal sort of, let's say, regret that I have. So that's, at least from my perspective, that's pretty much it. But see, otherwise, I see from a macro perspective, the mistakes that we make, every mistake under the son can be made. And that you're all aware, you're well aware of. There are lawyers who get sidetracked, there are lawyers effectively who I think burn out too early. Then, as I mentioned, there are lawyers who get a lot of cynicism about the system. And I'm not saying the cynicism is misplaced. Nobody here is saying that, everything is hunky-dory. But as I mentioned, that belief that there are good people in the system, the belief that despite certain incidents, ultimately the system is one which can validate, the law as such, as we know it in a utopian context. So that sort of fundamental confidence, the belief in the system, unfortunately, you will see a lot of lawyers losing that. And that will manifest in different ways. There'll be people who will get disgruntled, who will leave the profession. There'll be those then who will say, there's no point in researching. There's no point. Ultimately, we all know it's all done in some other way. So then people move on to different areas, etc. You know better than me. Because in terms of, say, the conversations that you might have had with your peers, like some of them will have a very cynical outlook. Now, and one just hopes that after some time in the profession, that outlook changes for the better, and that one retains that faith in the system. So therefore, so these are some of the issues. See, as I said, one should not be slavish to the extent of saying that, we live in some sort of paradise and that the system is the best. There are problems. I have written about issues which have happened in the judiciary. But, if all of us have that sort of notion that it's all gone, there's no point, then, there's nothing worth fighting for anymore. So that, I think, is, something which I thought, that existential crisis I've seen with a lot of people. And, we flirt with it every day. You have a couple of bad days, and suddenly you think, what is happening? Why am I here? So that I think is something which is very real.
Right. Thanks for that very honest take, sir. And the final question is something that I ask all the guests who've been on Letter of Law, sir. I do see an extremely beautiful law library behind you. So do you have any recommendations for our viewers, and any books that you think our viewers should take up?
Right. So see, ultimately, when it comes to law books, for a lawyer's library, a library can never be, let's say, too large, because, the scope is unlimited. You've seen a law school library, right? I mean, technically, a lawyer's library should be 10 times that much, technically speaking. But so therefore, see, at least in terms of the books, see, I don't think I have any real favorites per se. You have all the classics. So if you have, say, contracts, you will have a chitty. If you will have arbitration, then of course you have the well-known treatises within India. You have Justice Indu Malhotra's book on arbitration. Then internationally, obviously, you have a lot of texts like Gary Bond, etc. So see, I think at least in terms of the general, let's say, readings, I think, all the standard texts are there, and I don't think I have any particular favorites among them. But if I slightly digress, and I think in terms of generally the law as such, I think the most fascinating readings which I have ever done, also I think because they are more contemporary in nature as compared to some of his the people who came before him, is Ronald Dworkin. So Dworkin's books, I think, really, I mean, they were for me quite an experience in terms of, even though it's written from an academic perspective, but even as a practitioner, a lot of the things that Dworkin writes about, including the role of judges, the role of lawyers, is something which I thought was, it's something which is quite, it's quite thought awakening when you read it. So that is something I would, especially Law as Empire, that especially I think is a seminal work, and purely from a practitioner's perspective. As I said, I'm not really someone who can aspire to the level of theoretical analysis that a proper academic or a philosopher might do. But from a practitioner's perspective also, a Law as Empire is a brilliant read.
Definitely. In fact, Ronald Dworkin has been a repetitive recommendation on the channel. So to our viewers, I think now is the time to read Ronald Dworkin. With that, sir,
and I'm so sorry. And another book which I always recommend is Leila, Justice Leila Seth's autobiography. See, you have a lot of autobiographies, absolutely, in the profession. But if you want the perfect balance between a poignant life, wonderful years spent in the profession, and the general experience of being a lawyer and a judge in India before we reach the 21st century, I think it's beautiful, because there are some exceptional legal autobiographies in the country. We all know of them, Setlubad, Hidayatullah, etc. But I think they all have a let's say a very overt focus on the person as a lawyer, which is of course important. But that's why Justice Leila Seth's autobiography, I think, is slightly different, because the person, you actually get to meet the person, right? Which is not the case in most of the autobiographies, because you get to meet the lawyer or the judge. But with Justice Leila Seth, you first get to meet the person, and then you see that person transform into a lawyer and then a judge. That's the beauty of that book. So yeah, I can't recommend that highly enough.
I agree. And sir, I think with this, we can come to an end of today's conversation. Thank you so very much for taking the time out and speaking with me. I got to learn so much, and I'm sure our viewers would benefit from your insights greatly.
No, thank you so much, Arthur, for having me over. It's very nice to, sort of revise all of this, because then I think it's also a good way to go down memory lane and then, sort of just look back over the years. So thank you so much for the opportunity. It was a pleasure.
Thanks, sir. So I'll just stop.